So in a Florida divorce, whether or not somebody has an extreme amount of wealth sometimes can impact the outcome of your case, simply because a person who has more money typically has more money to fight. And that means they typically try to push for litigation more, which can cause your own attorney's fees to go up exponentially. In those types of cases, what an attorney can do to help you is try to settle things outside of court if possible, come to an agreement that works for you and your family as well while trying to mitigate the cost to you, even if the opposing party has essentially a larger amount of money to spend. So just because one parent makes more money does not mean that parent will get more custody or more time sharing. Typically, the presumption in Florida is still an equal time sharing. That's the base presumption. So whether or not somebody has more money or makes more money will not necessarily determine the overall outcome of your time sharing plan. It just may mean that it may make things more litigious going through the process. So in Florida, as a part of your parenting plan, what typically is included is a division of extracurricular activities, as well as potentially private education if you guys can come to an agreement. What that means is there's really two ways that it's handled. Typically, it's done if you guys agree to an activity. It's considered to be a mutually agreed to activity. You guys will split that equally. Now, if it's uncovered medical and dental expenses, typically that could be done via a pro rata share based off of your guys' incomes. So in Florida sets out 17 different factors for the best interest of the minor children. So the court is looking at all 17 factors when determining a parenting plan if you're not able to come to an agreement. Now, whether one person can pay for a private education, that necessarily doesn't matter, although you're more than welcome to pay for a private education for your children. Ultimately, the presumption is still going to be equal time sharing. In Florida, there are several factors the court considers regarding the best interests of the minor children, specifically in divorce and time-sharing issues. The court has to take these into consideration when drafting a robust parenting plan that essentially outlines how you and the opposing party is going to parent your minor children. Wealth typically does not impact those best interest factors. It can slightly, but it's not going to be a situation where just because somebody has more income, they typically get more time sharing. If you have any questions regarding divorce and custody or time sharing for high net worth individuals, please contact us at Cooper PA for a free 30-minute consultation.